Well, good morning, everyone. Buenos días. Muchas gracias, muchas gracias. Un gusto de estar aquí y compartir este espacio con todos vosotros. I will speak in English, though. In English, it's in English. Well, my fellow speakers, distinguished guests, ladies and gentlemen, good morning, everyone, once again. My name is Pedro Paulino. I am Deputy Secretary General for the Portuguese Peace Courts Council. And it's with great pleasure that I'm opening this panel on alternative dispute resolution and community justice mechanisms. Obviously, I'd like to... Oh, see? Okay. Sorry. I'd like to begin by thanking you all for your presence here today, and also to thank the organization by acknowledging the relevance of the topic that brings us here today. And as the organizer of the session, I am particularly honored to introduce our reflections on how we can make justice more accessible, more effective, and ultimately more humane, which is the main goal. I'll try to keep it short to give the room for my fellow guests, but I'd like to start with this. Justice delayed is justice denied. I'm sure you all heard this before, but this timeless axiom underscores the need for accessible and efficient mechanisms that truly serve citizens. And it is with this guiding principle that I'd like to invite you to explore the transformative potential of the local peace courts as an alternative dispute resolution mechanism, or ADR mechanisms, as you all know the acronym, that marries informality with judicial rigor and speed with solidarity. But ADR mechanisms are not new, as we all know. In fact, at least in Europe, informal dispute resolution predates even state courts. So the question is, why don't we use them more often than we once did? And I strongly believe that at its core, justice must qualify and not quantify. What do I mean by this? It means that it either resolves a citizen's conflict or it fails at justice at all. Pure and simple. And conventional courts are often too slow, cumbersome, expensive, and rigid. And I can say this from my professional experience as a lawyer myself. We all know how courts work and the bureaucracy that lies with all courts pretty much anywhere in the world. So in response to all these challenges, legal systems worldwide have embraced ADR techniques, primarily mediation and arbitration, which I'm sure my fellow panelists will talk about, to alleviate a little bit the burden on traditional courts. In local peace courts, as an ADR or an alternative ADR mechanisms, unlike mediation and arbitration, I think they occupy a unique niche. although they were rooted in ancient traditions, at least in Portugal, they were brought back in my country in the late 20th century to address this justice gap for everyday disputes. And they are structured as genuine courts within the Portuguese judicial hierarchy, but they are guided by principles of simplicity, informality, procedural economy, speed, and conciliation. But most importantly, the Portuguese peace courts system incorporates an optional pre-stage of mediation, which means that if parties reconcile, the case or the conflict will conclude without any judicial intervention. And if not, if parties don't reconcile themselves with the help of a mediator, then a justice of peace will issue a formal decision on the merits of the cause. So we have a two-way system. We have a first stage, which is not mandatory, with mediation. And if parties don't reconcile at the mediation stage, they will go to the court. So the justice of peace will issue the decision. So I think this dual track approach blends the cooperative ethos of mediation with the authoritative closure of a court. And this is, in my point of view at least, one of the major benefits of this system that I'd like to share with you all. When compared with mediation and arbitration, local peace courts deliver a balanced ADR solution. They are accessible to citizens, they are supportive of friendly settlements, but yet they are anchored on the enforceability of a judicial decision. They facilitate access to justice, they reduce costs for citizens and for governments, they accelerate dispute resolution, and foster community-oriented conciliation. And all this without compromising legal certainty, of course, that we all seek. And this is why, in a nutshell, and I promised you before that I'd like to keep it short, and I don't like to take away much more time at this point from my fellow speakers. But in a nutshell, I believe that countries all across the globe should seek models like the Portuguese one to facilitate the access to justice. Because while mediation has a voluntary mediator that tries to reconcile parties, or arbitration, they provide a team of arbitrators. I think this type of system occupies a unique niche, and it's very useful from my professional experience and personal as well. They truly have benefits for regular citizens. So again, not taking much more time at this point, but I'd like to throw some questions for all of us to think today. Do you think that systems like the Portuguese one, should local peace courts as a system handle more types of disputes, because as you all know, these types of local courts, they don't judge any type of disputes when compared to regular courts. But should this system handle more types of disputes, or would they risk losing its hallmark speed and simplicity that makes them so effective? Another question I'd like you to think is, does using alternative ways to resolve disputes, do you think it might diminish the role of lawyers in protecting citizens' rights? Or rather, does it push them to create new and valuable services? And can proliferation of ADR mechanisms somehow erode formal courts? All these are questions that we need to think and to address, but most importantly for me is, how can we make sure that people from all income levels have equitable access to justice, even when there are still big gaps in access to technology? So we live in a digital age. We all have smartphones. Even all legal systems are embracing new techniques, digital tools. But how about the citizens? How about the less favored citizens? How can they have equitable access to justice in the digital age? So, and this is a cornerstone problem for me, is that we all need to fight for the justice. We all need to relish the rule of law, democracy, but we need to put people first. And by doing that, we need to make sure that people from all income levels can have equitable access to justice. And that's why I think this system of local peace courts are truly beneficial as an ADR mechanism for societies in general. And I do have my own views and opinions on all of these points and questions that I just talked about, but I now leave them to my fellow speakers, looking forward to hearing their own thoughts on this. Once again, thank you for your presence today, and thank you for your attention. I will now give away the room for Professor Kong from China.
Thank you very much, Mr. Paulino, if I pronounce correctly. Thank you very much. You basically have outlined ADR and its unique role in dispute resolution, particularly in commercial matters. I will now present a whole picture. Instead, I would like to give you a small picture of how AI can be used in arbitration and, of course, in alternative dispute resolution in general, and what challenges that it may pose to ADR, particularly arbitration, what we need to prepare for the so-called AI age. In today's rapidly evolving technological landscape, artificial intelligence is making significant inroads in the realm of arbitration. AI, with its ability to process large amounts of data, analyze complex patterns, and make predictions, has the potential to revolutionize the arbitration process. Firstly, AI-powered case management system can streamline the arbitration process by automating administrative tasks such as scheduling hearings, managing documents, and tracking deadlines. These systems can also provide the real-time updates to parties and arbitrators, ensuring that everyone is informed of the progress of the case. For example, an AI-driven case management platform can send automated reminders for document submissions, reducing the risk of delays. Our chair has said delay actually is injustice itself. And ensuring compliance with procedural requirements. So AI-powered case management system can really provide a very helpful role in arbitration process. And secondly, AI can conduct document reviews in a perfect manner. One of the most time-consuming process of arbitration is possibly the review of large volumes of documents, maybe thousands, even 10,000, you never know. AI-powered document review tools can significantly reduce the time and effort required for this task. These tools use natural language processing and machine learning algorithms to analyze documents and flag potential issues. By automating document review, arbitrators and parties can focus on more strategic aspects of the case, such as legal analysis and argumentations. Lawyers and arbitrators are supposed to focus on what they are required to do. And thirdly, AI can also be used to predict the outcomes of arbitration. By analyzing historical data and patterns, predictive analysis can provide insights into the likelihood of success for different arguments and strategies. This can help parties make more informed decisions about whether to accept a settlement offer or whether to offer a settlement. Oh, sorry. And to formulate litigation strategies or arbitration strategies. For example, a party may be more inclined to settle if the predictive analysis indicates a low likelihood of success in arbitration. Fourthly, AI can assist in facilitating negotiations between parties by providing data-driven insights and recommendations. For instance, an AI-powered negotiation platform can analyze the positions of both parties, identify areas of common ground, and suggest compromise solutions. This can help parties reach a settlement more quickly and avoid the time and expense of a full arbitration hearing. Having said about all the opportunities that AI may offer to arbitration, we have to look into the other side of the coin. As AI continues to develop, arbitration is facing more and more challenges and exposed to more risks. First risk is lack of transparency. AI algorithms are often complex and opaque, making it difficult for parties to understand how decisions are being made. The lack of transparency can raise concerns about fairness and accountability. For example, an AI-powered predictive analytics model is used to influence settlement offers. Parties may question the basis for the predictions and whether they are being fairly represented and treated. The second risk is reliance on data. AI is trained on data. If the data is inaccurate, incomplete, or biased, the results produced by AI tools may be unreliable. Additionally, the use of AI in arbitration may raise concerns about data privacy and security, particularly in certain countries. As sensitive information may be processed and are stored by AI systems. The third risk is ethical considerations. The use of AI arbitration raises ethical questions about the role of technology in decision making. For example, should AI be used to replace human arbitrators entirely? If so, what safeguards are needed to ensure the decisions are fair and just? Additionally, there's a risk that AI could be used to manipulate the arbitration process or favor certain parties, raising concerns about ethical violations. So facing such challenges and opportunities, I think arbitration rules will have to be adapted to meet the challenge and taking advantage of the opportunities. Shareholders and the legal community in general must act to address the risks and challenges. For example, by amending arbitration rules. I have a few suggestions. Firstly, possibly we need to amend the arbitration rules to enhance the transparency and accountability of AI involvement in arbitration. To address such concerns about transparency, developers of AI tools for arbitration should be encouraged to make their algorithm more understandable and explainable. This can be achieved through the use of transparent decision-making process, documentation of the data sources, and the training methods, and providing opportunities for parties to challenge and question the results. Additionally, regulatory bodies and professional organizations can play a role in setting standards for transparency and accountability in the use of AI in arbitration. Second suggestion is that possibly arbitration rules can be amended to increase data quality and ensure data security. Ensuring the quality and the security of data used by AI tools is essential. This can be accomplished through rigorous data validation and a verification process, as well as implementing strong data security measures to protect sensitive information. Additionally, parties should be informed about the data sources and the limitations of AI tools to enable them to make informed decisions about their use. The third suggestion I would like to make is to amend the arbitration rules so as to introduce ethical guidelines. The development and use of AI in arbitration should be guided by ethical principles. Professional organizations and regulatory bodies can establish ethical guidelines for the use of AI in dispute resolution, addressing issues such as fairness, impartiality, and transparency. Additionally, stakeholders should be encouraged to engage in ethical discussions and debates to ensure that the use of AI is in line with the values and principles of the arbitration community. Of course, certainly my suggestions certainly will not be able to address all the issues, all the concerns. But nevertheless, I think that will be a starting point. That possibly can be a starting point when we are going to discuss the role of AI in arbitration. So I would like to stop here. Thank you very much. Yeah.
Well, good morning, everyone. My name is Craig Hansen. I am an attorney from the Silicon Valley in California. I run a law firm, the Hansen Law Firm, and we handle a broad array of complex business and intellectual property disputes. So generally 100% litigation, and our practice is growing into international disputes as well, which involves various forms of ADR. So let me first ask, how many people in this room have engaged in some form of ADR, whether it's mediation or arbitration? A few of us, okay. And how many people don't really know the difference between mediation and arbitration? We generally have a handle on that. Okay, good. So I do probably 10 to 15 mediations a year as a litigant. I haven't mediated cases myself yet. I plan to in the future, but so far as a litigant. I have several cases in arbitration now, and I'm presently representing a Dubai company in a lawsuit or pending arbitration against a California company. So this is a distributor in Dubai who had their contract terminated by their California customer, and they believe that it was terminated wrongfully, and that the customer then engaged in unfair business practices, such as trade disparagement and business interruption. So we're preparing to file an arbitration against the California entity. And so how do you arbitrate? If you're going to be doing business with, say, a company in California or the United States, how do you get into an arbitration forum? Well, I'm going to be talking a little bit about the ICDR. Does anyone know what the ICDR is? Ever heard of that? All right. So it's the International Center for Dispute Resolution. It's an arm of the American Arbitration Association, and we've called them the AAA. And the AAA is one of the major forums for mediation and arbitration in the United States. But what they have is the ICDR, which is their own international forum for ADR practices. So it's designed for international disputes. It offers neutrality and global credibility. It provides procedural safeguards from both civil and common law systems, making it a very reliable system for international litigants. So there's a lot of flexibility and neutrality in working with the ICDR. The participants can agree on the seat of the arbitration, which can be all over the world. So it's not just within California or within the US. They can come to you. You can also have the language of choice. So you're not beholden to having your arbitration or mediation in English. You can choose the language that suits your jurisdiction. And there's also, you get to choose the applicable law. So if you're in litigation either with a US company or with another country somewhere else, you could choose the law that suits your jurisdiction. And so you don't have to change the type of law you're dealing with. How do you get into the ICDR? So one thing is if you're going to be entering into business with say a US company, you could put an ICDR provision right into your contract. And they actually have sample language right in the ICDR rules that gives you a provision you could put right in there. So in my distributorship case, the distributorship agreement has an IDCR provision in it, and that's why we're going into that forum. So in going into this, we're getting ready to prepare, and I've been studying the rules, and as I mentioned, you get to tailor the rules to the procedures of your case. Once you get started, there is case management conferences that allow regular check-ins with your arbitrator, and electronic filings as well. So you can do all your filings online through the ICDR. It's very convenient. Also, if there's any form of emergency relief that you're seeking, maybe a restraining order, maybe the appointment of a receiver, something that you need to maintain the status quo while your case is pending, there are procedures for fast-track resolution when appropriate. The arbitration selection process is also flexible. Either the parties can agree to an arbitrator of their choice, but if they can't agree to one, there's an arbitrator selection process. So each side gets to have a certain number of arbitrators from the panel, and there's a strike list. And if you can agree, if you submit your strike list to the administrative body, and then they ultimately select an arbitrator for you. So it does guarantee a sort of a neutral selection process. And that's important because when you're litigating in a remote forum, fairness is important. And you can't have justice without fairness. So that's an appropriate way for dealing with neutrality. The procedures in the ICDR are confidential. So that's one of the unique things about arbitration is that a lot of people don't want to have their dispute become public. The case that we're about to go into, one of the parties is about to go public as a public company. And so rather than having the arbitration be sort of out in the open, out in the world, everything can be maintained confidential, which also promotes the resolution on a confidential scale. The fee structure is kind of good to know. It has a sliding scale. So the larger your claim, the larger your fee structure. So in our case, we're dealing with about $1 to $2 million in dispute. So as a result, the filing fee is about $12,000 just to get it initiated, and then another $18,000 by the time of your first hearing. So it's pretty significant filing fees depending on how large your dispute is. But if you're dealing with a multi-million-dollar dispute, it's worth it. You got to do it to get in there. And then you have to pay the arbitrators hourly fees as you go as well. So it can be expensive, but if you compare that to court litigation, over several years with attorney's fees and the amount of time it takes, you can get up into the millions of dollars in attorney's fees. So it's all comparative. So with our case, we're looking to file. Generally, you file your claim. The other side has 30 days to respond. They can file a response to the claim, add a counterclaim, and then there is an administrative hearing. The first administrative hearing is where you get to talk about the case management, how things will flow, how the arbitrator will be selected, and then you go from there. Then you start. There's a discovery process that you can agree to, or there's default rules for the exchange of information. But generally, you outline a discovery plan, and that will be enforceable with the arbitrator. So generally, depositions are not allowed under the default rules, but if, say, there's a witness or two that you need to depose, you can agree to that and incorporate that into the rules. So in any event, that's all I want to talk about a little bit was the ICDR. I think it's important to know that if you're going to be doing business either with someone in the United States or someone internationally, there is this forum that's available. It's accessible, and it provides a neutral place to resolve your dispute. Thank you.
Good morning, everyone. Yeah, I'm come from China, and I'm a lawyer. It's my first time to be here. Yeah, thank you. Yeah, it's a true honor to join you today in this panel. Yeah, in the next few minutes, I'd like to share some insight from the China's landscape in ADR, and we discussed the ESG dispute, and I will look a lot only at the strengths of ADI, but also at its limitations, and what we might do is improve it. Yeah. So ADI is by no means new to China. In fact, resolving dispute outside the common room has deeply hostile rooms, from village mediation traditions to today's institutional forms like people's mediations, commission arbitration, and court organized settlements. Yeah. So in recent years, China has dramatically expanded its ADR framework, strengthening both its former institutional and grassroots system. Majority arbitration commissions have seen remarkable growth. For instance, CIETIC alone has administered a case involving parties from 166 jurisdictions, with its awards recognized and enforced in other countries. Importantly, this institution aren't just growing, they are innovating. Yeah. CIETIC's 12.5 arbitration rules introduce international best practice. Yeah. Beyond the form arbitration, mediation plays a fundamental role in the China's justice system. Over 1 million people's mediation committees across the country handle everyday dispute in neighborhood and village, from the property issues to family and labor conflicts before they ever reach a court. Yeah. In sum, China's ADR landscape today emblems the skill, diversity, and innovation. We see busting the international arbitration centers, and at the same time, we see millions of local disputes being resolved through the informal, community-based process. This hybrid model reflects a long-standing Chinese legal culture that pride harmony and consensus. Now, let's now shift to a topic and get global attention: ESG disputers. Over the past years, the number of such disputers has increased worldwide, from the cases involving the environmental degradations to social conflicts and all supply chain violations. What makes ADR especially well suited to handle this type of dispute? First, ESG disputers often involve a wide range of stakeholders, not just companies, not just companies, but also committees, regulators, also NGOs. Yeah. So these disputes are rarely just legal. They are technical, social, and political, requiring dialogue and mutual understanding. Mediation, ADR tools are uniquely equipped to bring these parties together earlier, before positions become entrenched. Second, there's the issue of reputations. ESG dispute, whether about pollution, labor practice, or greenwashing, can cause massive brand and investor damage if they go public. Yeah. Third, expertise and flexibility matter. ESG disputers often hang on the complex technological issues, ADR allows parties to appoint a neutral with deeper subject expertise, whether in environmental societies, corporate governments, or social impact. Procedures can be customized, all of which would be difficult in traditional litigation. Finally, ADR helps the present relationship. ESG disputes frequently occur between the parties who must continue to work together. Business partners, local communities, or state actors. Unlike litigation, ADR can support long-term collaboration through the criteria, not zero-sum outcomes. So China is already seeing an overlap between the ADR and the ESG on the ground. Yeah, according to the arbitration, the worker report, yeah, the case is planned beyond the traditional contractor and equity the dispute into areas like green energy, ecological, and some compliance case. Likewise, local mediation committees now frequently address the disputes over noise pollution, public green space, or even waste storing, all of which touch on core ESG value. Now, we must be honest, ADR isn't perfect. It depends on party consent and equity bargaining power. If not decide carefully, stronger parties may dominate the process. And while parties can choose as per the natures, not all arbitrators or mediators truly understand ESG. So some critics also worry that arbitration loses their teeth, that it can't impose punitive sanctions the way court can. That's partly true, but arbitration can still award damages or performers. In some systems, a court can inform or transfer arbitration award into injunction. So the key is not to reject the ADR, but refine it. As the ESG dispute become more common, how can we make ADR ever better? My suggestion is, first, form mutual panels. Arbitration and the mediation institution should bring the lawyer, community representative, and ESG professionals, especially for complex environmental and social issues. Two, ensure participate the fairness. Communities and the weaker parties in ESG case should receive support to ensure their voice is heard in ADR. Three, encourage global exchange. So in summer, I think ADR is not a silver bullet, but it's a flexibility, the collaborative spirit, and adaptability. Make it one of our best tools for address the complex disputes. As ESG issues intensify, I believe that with thoughtful reform and shared experience, ADR can help us deliver the justice that is faster, fair, and fit for the future. Thank you.
Sentate? Ok. Grazie al coordinatore. Distinguished ladies and gentlemen, good morning. My name is Xie Wei, Associate Professor of School of Law at Xiangtan University in China. I had my doctorate degree from the University of Rome, La Sapienza, in Italy. So today, we can parlare in italiano, ma credo è meglio. Però... No, ok. No, in inglese ho dato la mia paper all'interpretazione, quindi tradurre è molto facile. Ok. Continuo. Today, I'm honored to share with you some insights into China's notarization system, especially under the context of the multi-dispute resolution mechanism. Because in China, so many people doesn't think that the law of the notarization is a part of the multi-dispute resolution mechanism. But in fact, it is. It have to. Yeah. First of all, let me briefly introduce the development of Chinese notarial system. China's modern notarial system began in the 1915s and has gradually developed into a key preventive legal institution. In particular, the notarization law enacted in 2005 marked a new stage of legal modernization for notarization in China. At present, there are nearly 3,000 notarial institutions and over 15,000 practicing notaries in China. It is worth mentioning that more than 10 million cases of notarizations are handled every year, including around 2.9 million foreign-related cases used in over 100 countries and regions. Next, I would like to talk about some recent reforms and progress in our system. On the one hand, China has promoted structural reform of notarial institutions. Many notarial offices originally under the government administration have transformed into cooperative institutions, which are independent, funded, and operated by qualified notaries. On the other hand, we're actively promoting digital notary services. Over 1,300 offices now offered online services, and cross-regional notarization has become much easier through digital platforms. In addition, we emphasize public interest services. In 2023, over 413,000 pro bono notarizations were provided, including those serving rural areas and vulnerable groups. So, what are the unique features of China's notarial system? First, notarization plays a preventive role. It helps avoid dispute before they happen. By intervening before a contract or transaction takes place, notarial acts reduce legal risks and ease the burden on the judiciary. Second, notarial documents carry strong legal credibility in China. For example, in matters like inheritance and property restitution, notarized documents are often accepted as strong evidence in court. Third, foreign-related notarizations has become a vital part of the international legal services. Since joining the International Union of Latin Notaries in 2003, China has deepened cooperation with other countries in this field. Finally, technologies has greatly improved notarial efficiency. Technologies like Brache and remote video notarization have enhanced both the security and traceability of notarization. Now, let me briefly share some key points in the upcoming amendment to notarization law in China. First, we aim to enhance the substantive review function, especially in high-risk areas like inheritance and real estate. Second, China is exploring a shift from an institution-based system to a more notary-centered model. This shift aims to promote the independence and professionalism of notaries. Third, we are working to reform the fee and compensation system to ensure fairness and improve service quality. Fourth, we will continue developing law to support digital notarization, especially regarding e-signatures and data preservation. Lastly, we seek to clarify the legal responsibility of rights of notaries, balancing accountability with protection. In conclusion, I would like to sincerely thank organizers of this conference. China's notary system is undergoing an important phase of reform and modernization. I believe that notarization will play an increasingly important role in the multi-dispute resolution mechanisms. I hope my presentation has provided useful insights, and I look forward to future dialogue and cooperation with you all. Thank you very much. Gracias. Gracias.
Well, thank you to my fellow speakers. Before opening the floor to the public, I'd like to hear you on a topic that Professor Kong addressed in its presentation. And I believe it's something that we all should think about. We live in a digital world. We live in an age with artificial intelligence. And my question is, and perhaps we don't find a definitive answer to this, but at least let's try to think about it, and I'd like to hear your opinions, of all of you, on this. Should we seek and rely more and more and more on tech, such as predictive AI, like you mentioned before? And how about the human element? And we are always talking about tech, data, safety of data. But what about the human element? I think that, and this is my personal point of view, that people tend to rely and cherish the human element rather than knowing up front that their data is secure. We all, as citizens, seek justice and a fair resolution, but I think that the human element, someone to talk, someone who can decide, someone to guide, whether it's a mediator, a judge, an arbitrator. I think the human element is particularly important in this age, because we must never forget that despite all technological wonders that we are capable of, we're human beings, and justice is a way to settle our disputes for human beings and by human beings. So I'd like to hear you on this, and where you stand on this, and your opinions on this issue, especially because I'm sure that most of you heard on the news last week that a lot of countries, but especially in the Iberian Peninsula, we got a total blackout for roughly 12 hours without electrical power. And so I can share you my experience, because I live in Lisbon, so I experienced it all. And it's weird because we are so used to basically taking everything for granted, like electricity and water and communications and internet and AI and all that. And all of a sudden, everything stopped. No light, no communication, no traffic lights, no nothing. And basically, we got back to like a prehistoric age. Because, and we were all staggering and looking at each other and like, oh, what are we going to do now? Because we are so used to all these tech, all these gadgets, and we have forgotten the human element. So sorry for sharing this personal story, but I'd like to hear you all on this issue and this conflict about the human element versus all the tech and AI and the digital mechanisms to help justice. I'd like to, I don't know, which one? Yeah.
So I have some recent experience in trying to incorporate AI into my own legal practice. I was just preparing for a 5-week trial. I didn't know it was going to be a 5-week trial, but it was a 5-week trial. And I was using AI for the first time to help me prepare for trial. So I said, all right, here's a deposition. Give me a deposition outline. And it did not generate what I was hoping for. It was, okay, here's 5 or 10 points that are in this deposition. And it was just not usable. So it did take me to actually go through the deposition, prepare the outline, and then which I used to prepare my cross-examination and all of that. Also file review. It looks for what it thinks it's supposed to look for, but it does take real human direction. So in my experience, using AI, it's part of a litigation tool. It's just that, it's a litigation tool. It requires a lot of thinking from the human standpoint to give it the prompts that are necessary to make it usable. Otherwise, it's not usable. So it's not a replacement for human beings. People say, oh, you know, are you worried about your job? Someday AI going to take over what you do? And I just don't think that's something to worry about, especially if, as litigators, as thinking people, it's the human insight and human perspective that I think will continue on indefinitely. And AI will be a wonderful tool to help us guide along the way, but not as a replacement. And just on the other perspective, after 5 weeks of trial, after every objection that's made to evidence, every ruling that's made by the judge, every strategic decision that's made by the trial lawyers, which witnesses to call, which questions to ask, what order to present them in. These are all things that I think require human thought, perception, intuition, skill, experience. But AI can certainly be there to help us along the way, but I don't see it replacing us anytime soon.
Can I respond? I do agree with my fellow speakers that AI shall be of the people, for the people, and by the people. But nevertheless, to let AI play a bigger role actually does not lie. I mean, we actually are forced, at the end of the day, we are forced to accept to let AI play a bigger role. So the point that I would like to share with you is that we must be prepared for such a time when AI is going to play a very bigger role. To some extent, even our traditional way of legal, as a legal practitioner will be replaced, or at least will be more or less replaced by the AI technology. So we need to be prepared. I do not think at this moment we are in a position, AI is in a position to substitute us, as we are, after all, we are human beings, and as I said at the very beginning, just like AI is of the people, for the people, and by the people. I do not disagree with that. Thank you.
Thanks. I would like to see AI and the super smartphone, just like other software. For example, ChatGPT, DeepSeek is coming so fast. But what we can do is not too far away from this software. We have to resolve the problem that this software brings. The change is also into the area of the education, because I am a professor of the university, and all my students use the software of AI to make the paper, to make the homework. And how can we do to face a new problem that the AI brings is what we can do. Okay.
Yeah, in my opinion, I think that AI is useful. Everything in the world is useful. Yeah, so AI is also useful. But I think because the world is controlled by the human being, so the AI, yeah, it's not can dominate the human being. It's just assistant and improve our to live better, to work efficient, and so on. Yeah.
Thank you very much. I think we all can agree that although it's a wonderful tool, AI I think it's a bit tough to say, but it's difficult to replace the human element, especially on ADR mechanisms that rely so much on the human element. Thank you so much. Let's now open, I think we have roughly 10 minutes for a few questions from the floor. So please, if you want to ask questions, raise your hand. Wow. I don't know, the mic?
Thank you. Good morning. Welcome to Dominican Republic. For us, it's an honor to have specialists here as your level. Quickly, here in Dominican Republic, we are more mature in commercial arbitration and introducing public administration contracts with disputes resolution. We are too many cases experienced in that order. But I think we have the lag in resolutions and civil and criminal first level of the laws cases. The community has in his DNA litigation at first level. So we have to change that mind to throw those people to the community centers that the civil courts has preparing here in Dominican Republic. In your experience, how we can change the mind of the people that has the litigation at the first side, that okay, they go to the court, just simple cases of non-payment contract, problem with community for neighborhoods, state. So how we can change that mind and do it better in the experience of your country. Thank you.
Hi, in this same order. First of all, sorry by the language. I will try to do my best to it in English. If in case the translator could help me, but I will try to do my best. So my comment is in this same way. I'm a ADR teacher in the UNAPEC, and what I try to do in these cases is to try to get the students near to the techniques. You know, you was talking about the no formal process, and I like to do that. I try to speak the less of the arbitration system, because it's like the private ordinary justice, you know? So it has the same handicaps and it's expensive. So I try in my classes to talk about the techniques so my students can use it as a lawyer in his practice, like authentic mediators or conciliators. I know that it's informal, but I try to do it just to try to change the mind of the students to know that they are techniques that they can use to do better his job.
So I could respond to both. In terms of getting parties away from litigation and towards resolution, there's a couple of ways to approach it. One is procedurally. So with the ICDR that I talked about, the default rule is that you will participate in mediation unless your contract says that you can opt out. And most people don't want to do that. So as part of getting involved in the process is you have to mediate before you can arbitrate, and you got to do that early. So I think that's an important thing. And then also I think educating people about the benefits of mediation as opposed to arbitration. And we always say that it gives you certainty over the process. You're not giving your dispute over to someone to decide for you. It gives you peace of mind in that you get to resolve your dispute rather than go through all this stress and burden of arbitration or litigation. And then, of course, there's the financial piece as well, is that once you can resolve your case, you're not spending time and money on attorney's fees. So I'd also, just as a comment, I'm noticing a shift even at the court level. I've had 2 trials recently that turn into mediations or judicial resolutions. So I had a trial that was scheduled for a week-long trial. The judge said, hey, rather than trying this case, why don't you turn me into your mediator? And we did that. It was a marathon mediation. It lasted a week long, but we resolved 16 distinct issues in that case, and it worked. I had a second trial where they did the same thing. It was a 3-year-long litigation. We finally got to trial, and the judge said, well, let's go ahead and settle this case instead. So there's a shift in philosophy, there's a shift in culture away from litigation and more towards mediation and resolution, and I think it's for the better.
Let me just add on what you said and trying to answer your brilliant question. Thank you so much. Like you said, the problem is that people always rely, I think they are used to courts, and it's difficult to change the mindset. Although there are many benefits to seek other ADR mechanisms, whether local peace courts or arbitration or mediation or whatever, people think that if it's on the court, it will be better settled. And it's often not the case, because although the court will apply the law, perhaps it won't be the best settlement for that specific dispute. So I think that one of the bigger problems is the shift on the mindset. And on top of that, as a lawyer myself, although I'm not practicing at the moment, I think lawyers play a big role, because by default, we want to go to court, because that's where we can share our skills, that's where we can show our clients what we do and why we do it, and play with, like you said, strategic decisions. So I'd say it's a mix of educating people and also by lawyers not to seek court as a primarily rule, but to advise citizens that they can solve their problems by seeking other ways of dispute resolution.
Let me just add one anecdote to what my fellow speakers have said. In the Chinese context, ADR actually can be found actually everywhere. For example, mediation can not only be used as means to dispute settlement, but also be incorporated during the process of arbitration. Throughout the arbitration process, mediation can take place upon the request of parties or upon the agreement of the parties. Even during the litigation process, mediation can also take place whenever there is agreement between the parties. So I think institutional arrangement possibly shall be first made before indoctrinating lawyers and particularly their clients. Yeah. This is my explanation.
Buenos días. Yo soy abogada y soy notaria y también soy maestra. Excelente panel, sin desperdicio.
Muchas gracias.
Sin desperdicio, de verdad que sí que me ha gustado muchísimo.
Muchas gracias.
Voy con el último exponente y lo referente que él hacía a propósito de la ley de notaria y cómo se aplica ya la notaría en China. ¿Qué acontece? En nuestro país depende mucho de la implementación de las leyes dependiendo de los actores. Nosotros tenemos un poder legislativo que es el que no aprueba las leyes. Yo recuerdo 2018 o 2020 que los notarios de la República Dominicana participamos en una asamblea general para someter una ley de intermediación notarial, que uno de los puntos que consistía que nosotros como notario hiciéramos las veces que hacen en China, la digitalización de la notaría. Pero ¿qué acontece? Llegó y se publicitó la plataforma de Indotel, porque la labor de digitalización de la notaría es a través de una plataforma, como lo tienen otros países de Centroamérica. Pero ¿qué acontece? Me parece que fue en el 2007 que 2017, que Indotel, que es acá la que hace la labor que tiene que ver con aspecto público para todo lo que tiene que ser la digitalización. Pero ¿qué acontece? La plataforma se puso en implementación, pero todavía no se ha podido. Pero ¿qué acontece? La ley de intermediación fue conocida en primera y segunda lectura, si mal no recuerdo, por la Cámara de Diputados. Pero después de ahí ha quedado hinchivada. Entonces uno dice, bueno, nos gustaría hacer como en China, porque dentro de la intermediación lo que vamos a fungir es que hayan casos que no tengan que llegar a los tribunales.
Sí, sí. Y su pregunta, por favor, porque tenemos
Sí,
muchas
sí.
más.
Entonces, en ese sentido,
Para el panelista.
Sí, sería bueno, por ejemplo, que ustedes como panel hicieran tal vez una propuesta a partir de las experiencias que tengan acá, tal vez del Poder Ejecutivo o al Colegio de Notarios o a los señores legisladores. A ver, ¿cómo pueden ustedes hacer llegar sus experiencias de sus países a nuestros respectivos funcionarios, a ver si eso ayuda un tanto?
Muchas gracias por su pregunta.
Ok, grazie. Quindi parlo italiano perché non posso capire molto la sua domanda, però in Cina abbiamo già un membro di Internazionale Unione di Latino Notariato, quindi abbiamo già fatto tanta cooperazione tra i paesi. Però la domanda è esatta no.
It's difficult because it's rather than a question, a seek for a shift in the system. And you mentioned like very well, and it's basically on every country. It's difficult to pass on laws. First, it's difficult to pass a law, and secondly, sometimes it's difficult that law will reach the results that legislators would want to. Sometimes we have laws to address an issue just to find out that it was passed, but it won't resolve the problem that it was supposed to. But anyway, I don't know if you want to.
I got
add.
it. Ho capito un po'.
Please, in English.
In English, okay. Currently, foreign-related notarizations from China to other countries, we have accepted in circa in 100 countries and regions, but the recognition is more useful, more accepted, but the notarization is not, come dire, it's a little difficult to pass away all the law of the countries in recently. Yeah.
Thank you. One final question, I think.
Okay. First, thank you all for excellent presentation, especially to Mr. Fernando Tonim for very practical. You can hear me? Yes, very practical presentation and examples. At first, I should have been the part of your panel, but organizer decided to move me in another panel in accordance with my scope of scope of expertise. Yes, I will shortly say something. I do not have a question, but I want to say something what is important to me. It could be very useful for you, I hope so. I'm a judge, a civil law judge in the Court of Appeal, but I'm also a network judge in the International Hague Network of Judges. I am dealing the most with cross-border child abduction cases and other family disputes. But in this sense, I want to say, if we want to have a real succession of one international standard or international document, the interstate cooperation is necessary. In these cases, if we have on the one side the state that ratificates some international instruments and in the other side, the states that is not, it could be a problem. If there is not a bilateral agreement, it is a serial problem. If we have on the one side a state whose legal system is based or influenced on Sharia law, it's a huge problem. In this sense, we are thinking a lot what to do, and I have to say that the Council of General Affairs of Hague Conference decide to establish working party or cross-border family mediation. This working party is established in the context of Malta process. I don't have a time now to speak about that, but if you are interested, you can Google. Because what is the crucial? In the absence of any international agreements or instruments, mediation could be the only solution in these very complex and very sensitive cross-border cases. So please, if you are interested, I will not take more time. If you are interested, please contact me. I can give you my contact and we can be in touch. Thank you.
Thank you. Thank you for your comment. Unfortunately, we don't have more time. Thank you so much for your presence. I'd like to extend my warmest regards to my fellow speakers. I hope it would be beneficial to you, and thank you so much once again for having us. Muchas gracias a todos.